Hello and welcome to the Did You Know series. Today we'll talk about emotional harm in tenancy law. Today let's talk about something that doesn't get enough airtime in tenancy law, which is emotional harm. Yes, the Tenancy Tribunal can and does award compensation for it, and we've got case law to prove it. In 2020, the tribunal ruled on a case and awarded just $200 compensation for unlawful entry. But the district court overturned it, calling it insulting and increased it to $2,000. Why? Because it wasn't just about physical entry, it was about a serious breach of the tenant's rights. Then, in a Housing New Zealand case, the tribunal laid down three key factors when addressing emotional harm. The first one was to do with the nature of the breach. The second was to do with the length of time that it went on. And third, and most importantly, the impact that it had on the tenant. For context, $3,000+ is the compensation that can be awarded for serious emotional impacts like fear, humiliation, or intimidation. Now here's a real case. In January 2024, a tenant was told that minor work would be done on his deck, which would take a week or two to complete. Instead, from March until the end of his tenancy in September, he faced demolition noise, builders on site, safety issues for his kids, and zero use of his deck, garage, or car park. By July, even the garage had a plywood sheet for a door, and he was parking on the street daily. There were no direct expenses, but the tribunal found it was a clear breach of peace and their privacy. The award? $2,000. Key takeaways from all of this is emotional harm counts, the tenants can claim for it, and the tribunal looks at the severity, the duration, and the impact. Even without receipts or invoices, long-term disruption justifies compensation. So quiet enjoyment isn't optional, it's protected.